Let's get into this. Let's get into the show. 7 facts in history on private trust, man. Look, I like to lay the foundation. You know, that's what we do here. We lay the foundation. What is the foundation? You know, I mean, the foundation ultimately, when it comes to this economic system and how you yourself go about conducting business in the public, or in, you know, the public realm, or in the commercial realm, or in commerce, or however you articulate it. So, you know, relaying the foundation of education and understanding of, you know, not only owning method and controlling everything, but, you know, titling assets, what the foundational structures were, and of course that was trust. But people get into this thing about, you know, being fearful of the Internal Revenue Service, and I can understand that, you know, I really can. But with the proper foundation, you know, which is going to be knowledge, you can, you know, really, you know, potentially, in a lot of ways, avoid any type of negativity when it comes to private trust administration, let's be honest. And of course, I don't give legal advice, not an attorney, not a lawyer. You know, it's not legal advice, tax advice, investment advice, relationship advice. I don't give mechanical advice. I don't give astrological advice. You get the idea, right? But, you know, I like to get into the history. You know, because history ultimately and law are connected. You can't learn, it's almost impossible to learn law without learning history or some form of history, and vice versa. It's almost impossible to learn history without applying the time's particular laws to, you know, the specific time's particular events. But the type of trust that, you know, we advocate, that you learn how to administer for your benefit, for your family's benefit, if you could only conceptualize the benefits of trust, you would do whatever you had to do in order to get this training. I guarantee it. If you could only knew and could actually personalize, you could learn the benefits and then personalize them in your life, you would be breaking your neck. You would be selling stuff. You would be doing everything that you could do to get over here, get into the training, to get to, you know, quote, the private side. But bottom line, you know, 7 facts in history on private trust. The validity of the trust entity or the contract entity specifically is not to be questioned. You may hear me say that many times. I say it whenever I get a chance to. It's not to be questioned. The validity of the contract entity is not to be questioned. You could call into question certain specific actions, transactions of administration of the trustees, but you will never and can never question the validity of the entity itself. There are 2 completely different types of trust in America today. There's a statutory trust. These trusts that owe their existence to legislation, therefore they're governed by legislation. And you have non-statutory trusts or common law trusts, or they're also known as peer trusts, or true peer trusts, or Massachusetts trusts, or contract business trusts. Or there's a lot of different terminologies for them. But ultimately, and this is what I want to say. I mean, look, let me just start off with this, because it's not about what I'm saying. It's not. I don't think it ever will be. Not when it comes to trust administration. Ultimately, what I'm saying or what I'm doing is based off of me being trained, my knowledge, my education, and proven actions and administrations of mentors and successful trust administrators or trustees. Namely, I studied the Rockefellers and the Carnegies and the Mellons, those administrators, Goldwaters, those wealthy families, and, reading some of the cases that, some of their assets or trust estates were dealing with. So, ultimately, it boils down to fundamentally understanding that, you have trust that exists by the common law right to contract, and you have trust that exists by way of statutory authority. That's ultimately the difference or the delineation between public trust and private trust, ultimately. And, in the absence of statutory restrictions, there is nothing inherent in this true or private contractual trust to prevent it from carrying on any kind of lawful business activities that individuals, partnerships, or corporations might engage. But let's get into it. Where's my notes? Got my notes? Okay, here, these are my notes right here. All right, look. So I wanted to say, I want to start off with what the Supreme Court said in Berry versus McCourt, where they were speaking on this type of entity, stating, quote, "It is not so much as a trust as a contractual relationship based on trust form." It's a contract. It only comes under trust law, and all the income is dispersed and all the income is taxed. And in all other situations, it's a contract. But let me get into this, like I said, 7 facts and some history. Private trust, okay? Private contractual trust, they came here with the colonists, and the colonists themselves, the framers of the Constitution, actually executed the Constitution itself under the English common law right to contract. And the oldest trust known in America is the North American Land and Cattle Company. The North American Land Company or North American Land and Cattle Company. It's over 200 years old, and it's still in operation today. It was set up by Patrick Henry, who was a famous attorney in 1765, which was 24 years before the adoption of the Constitution. He set this trust up for Governor Robert Morris of the Virginia colony. And this is back in the day. This is over 200 years ago when attorneys, famous attorneys at that, were setting up private contractual trusts. Well, I guess he was a governor, so, he's probably informed or something like that. So that's some history right there. North American Land Company or North American Land and Cattle Company. I don't know. Can't remember. Can't read my notes. But I know his name was Patrick Henry. I know the year was 1765. I know 1765 is 24 years before the adoption of the Constitution. And I know that Patrick Henry set the trust up for Robert Morris. And I know it's still in operation today. William Bingham, that was number 1. Let's move on. Can we move on? William Bingham was supposed to be, according to most of the richest American when the 13 colonies won their independence. He created a contract period trust for his vast estate back in 1904. The trust owned 2 million acres in Maine, which sold. They sold it. It was about the time of the Civil War. Bingham was a senator from Pennsylvania senator, and he owned a lot of land. He had owned a lot. The trust was terminated by the trustees in 1964. So 160 years later, it operated. It was terminated because of the multiplication of beneficiaries. There was over 315 beneficiaries, and the trustees was like, we're good. Nope, we have the right to terminate the trust, and they executed it. And there was a liquidation of the assets. Throughout the years, the incomes from the property and the proceeds from land sales were distributed to the beneficiaries. At the time of liquidation, it had no termination date. During its existence, and this is the benefit of these types of trusts, it was not affected by death, tax, probate procedures, state tax, none of it. What is that? That was 2? Was that 2 or 3? I'm not keeping count. So let's move on to the next one. This is, what is this, 4? 3 or 4? 3 or 4. There's a peer trust that was set up in Minnesota. It's called the Masabi Trust. It owns the reserves of the famous Masabi iron deposits. The trust receives the royalty payments from the iron deposits and distributes the royalties to the holders of the certificates. Following the transfer of assets from the company to the peer trust, Mr. Arnold Hoffman, who was at that time the president of the Masabi Iron Company, announced in the Wall Street Journal on March 14, 1961, that a ruling by the Commissioner of the Internal Revenue declared the trust would not constitute an association of persons taxable as a corporation. The shares of the beneficial interest are traded daily on the New York Stock Exchange. Daily. What is this, 4 or 5? 4 or 5. Multi-millionaire building supplier Edward Hines established a $12 million trust in 1914 and headed his business until his death in 1931. His 2 sons, Ralph and Charles, succeeded the elder as trustees of the trust and retained trusteeship of their father's trust after a court fight. So they kept it. They won the court fight. The court fight was instituted by 2 nieces, a sister, and a nephew, who sought to break the trust by claiming the administration of the family estate had been erroneous. The court ruled that the peer trust was not an erroneous method of managing the assets and was in fact a valid and legal arrangement for the estate. Valid and legal. The validity of the trust entity is not to be questioned. Supreme Court's talking, lower courts, go to sleep. Go to sleep. Ralph Hines, the eldest son and head trustee, died in 1950, and again, the family assets held in trust were not distributed by estate and inheritance taxes. Disturbed. They were not disturbed by estate inheritance taxes. The younger brother, Charles, subsequently became the head trustee, handling the trust for many years, preserved intact for future generations. The Edward H. Hines Lumber Company is still in operation today. Was that 4 or 5? Was that 4 or 5? Here's 5 or 6. William Waldorf Astor. Sound familiar? Astoria? Waldorf Astoria created a $50 million trust estate by a conveyance to trustees recorded in New York, August 15th, 1991, thereby saving his heirs several $1 million, which have gone for probate costs and death taxes had the estate been distributed by the court instead of the trustees. I'm going to read that again. William Waldorf, William Waldorf, a store, created a $50 million trust estate by a conveyance to trustees. A conveyance. Recorded in New York, August 15th, 1991, thereby saving his heirs $7 million, which would have gone for probate costs and death taxes had the estate been distributed by a court instead of trustees. The estate was still distributed, still divided up amongst the heirs. It just there was no death tax, there was no estate tax. Which would have been assessed had it been distributed by a court. Heavily studied these guys, Rockefellers. They use various trusts, various kinds of trusts for maximizing privacy. Excuse me. The Rockefellers, the Carnegies, I studied these. Before his death in 1937, it was reported that Rockefeller had over 70 trusts for his descendants. It was a vast web of individual and group funds represented considerably more than $1 billion. Nelson A. Rockefeller and his generation are believed to have reduced their personal holdings by the creation of still more trusts for their own grandchildren and great-grandchildren. It has been reported to one source that there are well over 100 and perhaps 250 individual Rockefeller trusts. Many of these trusts are known to be pure trusts, placing the funds beyond the reach of the high cost of probate. What was that, 6 or 7? 6 or 7? Okay, this is 7 or 8. You know, I'm going fast. You can, if I can download this, you know, do what you need to do. I know I'm moving. We're moving. There's my notes. I'm looking at my notes. Oh, we got some Supreme Court dancing real quick. Yeah, why not? History. This trust derives no power, benefit, or privilege from any statute according to Crocker versus Malley. The few state constitutional provisions that declare the term corporation shall be construed to include all associations having the powers of corporations not possessed by individuals. Has not been made or has not made the pure trust illegal, as was held in the State X Rel Great American Home Savings versus Lee. There is also sound legal evidence to support the fact that a true trust is not an association and will not come under any constitutional provision of a state. The U.S. Supreme Court states, quote, "We perceive no ground for grouping the two beneficiaries and trustees together in order to turn them into an association by uniting their contrasted functions and powers, although they are not in the proper sense associated. And through owning nothing, controlling everything, trustees holding property does not mean that the trustees own personal property. Trust property cannot be held under an attachment nor sold upon the execution of the trustee's personal debts, as held in Hussey versus Arnold. The powers and duties of the trustee are set forth in the indenture and are effectively limited thereby. So, I'm just going to leave it there. You know, I think number one, I lost count, so I'm going to need y'all to rock with me. I know I said 7. Might have been 8. Could have been 8. Not sure. Probably could have been 9 or 10. But, you know, I try to get that value. But ultimately, it's not about what I say. It's not about what any guru says. It's not about what anyone really says. Anyone on YouTube or anyone who's read a document 20 times and think that they're straight up a master. As far as I'm concerned, in true reality, it's what the court says, what the Supreme Court says. Primarily, because the Supreme Court is the only venue that protects the constitutional right that disallows the impairment of an obligation of a contract. There's no statutory trust is doing that. Only private trusts are doing that. Peer trust, true trust, unincorporated business organizations, Massachusetts trusts, true peer trust. There's a lot of different referring or referencing names for these types of entities. And, you know, not to be confused, we just fundamentally separate the trust by, is it created and does it owe its existence to statutory authority, or is it created and does it owe its existence to the common law right to contract? It's plain and simple right there. And if it is created and owes its existence to the common law right to contract, the grantor in crafting the trust indenture can imbue the contract with whatever jurisdiction they decide to. And the trustees, through a resolution of the Board of Trustees, can do the same. And as long as it's not under any statutory authority, and as long as the jurisdiction is heavily contemplated, there's not going to be any issues. There's going to be far less issues than we would ever understand. A lot of the benefits of trust administration, of owning nothing and controlling everything, can only be quantified by way of experiencing the benefits through your application of knowledge of private trust administration. That's why I say, if you could only conceptualize the benefits of private trust, you would do whatever you had to do in order to get this training, in order to get this knowledge, in order to get set up, to get properly structured, to get the information that's necessary to properly administer these private entities with all of these benefits contractually, and maximizing the private substantive administration that allows for the almost, in some cases, complete repellent of not only statutory fees and regulation, but also in taxation. Let's just be honest. That's one of the biggest things. People, want to protect their assets as well as protect their current and future income from exorbitant taxation. If you went to work and your boss said, "I can give you a check for $700, or I can give you a check for $3,000. Which one do you want?" You're going to say the $3,000 check, man. if you had the money in your hand that you're losing by continuing in the way of doing business, entitling assets, and generating income that you've been taught, if you had the money in your hand and then it was taken from you, it would be different. But since you don't know what you don't know, or in a lot of ways don't know what you're missing, it's kind of like the ignorance is kind of bliss situation. But it's just up to me to bring awareness to this. It's up to me, so L, to, take on the cause as well as the contractual obligation and fiduciary responsibility of being a trustee of the foundation. And acting upon its purpose, its educational purpose. Which is to teach this information. There's private ways of doing business. There's private ways of protecting assets. These private ways are very powerful. These private contracts are more powerful than the states. These private contracts are more powerful than the United States government. The only thing that puts them at risk is improper administration, not knowing how to properly administer or operate these trusts is the biggest issue. I read a lot of case law. I'm telling you. I'm not lying to you. So, it's a big thing to understand these things, but it's a big thing not only to begin with the firm stance on a proper foundation. Hey, check it out. We got about, 60 seconds left in the broadcast. If you're checking it out online, you want to call in. Otherwise, you will be disconnected. The caller number is 563-999-3625. It's 563-999-3625. Otherwise, you will be cut off. Well, we wrapping up the show. I'm gonna wrap it up. I'm gonna wrap it up for y'all. I appreciate y'all checking out the show. But yeah, we're gonna keep putting out this education. We're gonna keep doing it. And I ain't gonna say this. We applaud the beginner. The public is a situation where a lot of people are expected to know things. If you don't know things, people tend to clown you or make you feel bad about your lack of knowledge and stuff. We applaud the beginner. We applaud those who don't know. I applaud those. We applaud those who are like, man, I don't know what
10 seconds.
I'm doing here. I don't even know what really is going on and why I'm even talking to you, so L, but I know I'm supposed to be here. And I need to learn this stuff. Those are some of the best trustees. They learn fast. They pick it up quickly. They're solid in their stance, their knowledge, and the application of that knowledge. They understand the responsibility as well as the power that comes along with this type of information. But you got to get the information. Without the information, you can't apply it. So I invite you, email me, admin@welcometothefoundation.com if you're interested in trustee training, or you can check out welcometothefoundation.com and peruse the education tab if you're just getting started off and you kind of want to go at your own pace for now. But, I feel like eventually you're going to get in the training, or you have to get into some sort of training because, all of this stuff cannot be ascertained without mentorship. And, that's a big part of what we provide in the training here at the foundation. So, I also do consultations. You can book a consultation, get on the phone for an hour. Usually it ends up being longer than that. But you want to start a business, you want to help with your business credit, you have some minor, personal credit questions, if you want more information on private trust, you got a personal situation, you want to know how, this trust information and proper structuring of public entities can apply to your personal situation, definitely I would suggest setting up a consultation. A lot of people looking to go to LegalZoom. LegalZoom charges a lot. Filing fees to setting up a public structure typically is around $100. What is LegalZoom, like $700? But they gave me a corporate seal. A corporate seal, I don't know, for like $50. Not that much. It's not worth $700 or $600 LegalZoom. Why don't you book a consultation for $55? I'll walk you through the entire process on the phone, including getting the EIN for the business. Including that, as well as we'll talk about federal entity classification. A lot of people miss that. LegalZoom misses that. They definitely do. So New Year's coming up. Might as well treat yourself. Book a consultation with Sot L. For the new year, or for the pre-new year, you can get your business set up, get your private trust set up. There's no time like the present. But I appreciate y'all. I really do. I appreciate y'all checking out the shows. I see the numbers. As they grow. I'm very appreciative. I'm very humble that, the interest in this information. This is like, for real, let's be honest, this is kind of nerd stuff, But, nerds get paid, if I can keep what I make and pass it to my children without the state taking the chunk, let's do it. And mitigate taxes, pay less or no taxes. Sign me up. Sign me up. Sign me up. But that's just me. I don't know. That's just me. I was down. I was super down. I was too down, probably. I was gung ho. That's what they say. Gung ho. I think it's gung ho. G-U-N-G. Could be wrong though. I could be wrong, but yeah. I appreciate y'all checking out the show. I really do. I trust y'all have, if you do celebrate, you have, luxurious holidays. I'm saying that like I ain't doing another show until, next year. That's not the case. I'm just saying, if I don't say it next time, I'm saying it now. But I'm not going to take any calls, y'all. I'm tired. I'm going to be honest, man. I woke up too early. I don't know what I was thinking. And I'm paying for it. I'm paying. So, no callers, no callers this evening, but I appreciate y'all checking out the show. I definitely appreciate the live callers, And, we're just going to continue to get better. We're just going to continue to acquire and accumulate assets and accumulate wealth. We're going to continue to acquire and accumulate knowledge and information, and apply this knowledge and information correctly. Because, as you know, incorrect information incorrectly applied can get you hurt. But, the ability to do things, to partake in activities, to have the financial backing and foundation to do pretty much anything you want. You can drop whatever you want, go down to the airport, and fly anywhere you want in the world. That is available to everybody. It's available to you. You just got to do things differently. In order to create a different result, you must do different things to get there. I mean, it sounds simple, but it's hard for us to get out of our ways. So, I believe in you, and I believe that you can really reach your fullest potential when it comes to being a steward of your wealth, a steward of your life, your energy, and how it is translated or expressed here on this physical plane. Your energy is expressed in your car. It's expressed in the clothes that you wear on your back. Your energy is expressed a lot of times in the food that you eat. It's expressed in the experiences you have. You go to a movie. Did you you go skydiving, whatever. All of these things require currency. They require, quote, money. And in order to get this money, you must exchange your energy, your life, in order to do this. So to me, it's that serious and it's that deep to me. And, you know, it may very much help you respect your life and respect your time if you start looking at it like that. Because your energy is a non-renewable resource, you know. There's going to be one day where, you know, this vessel is no longer functioning. And, you know, time is way more valuable than money. And you should seize control of your life. Seize the day. And, you know, do the things that you must do so that you can live your best life every single day. Wake up when you want to. Do what you want. You want to sit there and play a video game for 8 hours? Can't nobody tell you nothing. It's maybe your husband or your wife, but no one else. Well, most people who have the opportunity to sit around and play a video game for 8 hours will not, because we understand the value of our energy. And I trust that not only do you know or are learning the value of your energy, but you are pleased with this episode, 7 Facts and History on Private Trusts. You know, it came from my notes. Do it together, blah, blah. Well, I trust you were able to learn something, you know, and, you know, maybe I trust that this was a measure of adding something to the foundation. That's all we're looking to do, to build this foundation. So with that being said, appreciate you checking out the show. You know, all the OGs, peace. Anyone new, how you doing? Thanks for checking us out. But y'all have a great week. You know the drill. Enjoy yourself. Take care of yourself. Make sure you say 10 things that you're thankful for before you go to sleep tonight and every night. It is very important. And I'll catch y'all next week on the same spot, the hottest radio network on the planet, High Frequency Radio Network. I am your host, Sot L, at Seeker of Truth L, Speaker of Truth L, and it has been a pleasure. Y'all take care of yourself. Enjoy yourself. Peace to the gods.
Doing this thing all the way live. High Frequency Radio.